now we're going to go over, a book, we're going to go to the verse in this book called The Myth of Rights. In The Politics of Right, Stuart Steingold appeals to the law's symbolic life. You know, Many abortion rights supporters have not anticipated such possibilities and instead have fallen victim to the myth of rights, an ideology that fosters a naive faith in the impartiality and functionality of the judiciary. In The Politics of Right, Stewart appeals to the law's symbolic life to understand the political importance of American law. Steingold insists it is not enough to consider the concrete manifestations of the legal institutions or to take into account the immediate reactions to or compliance with legal rulings. These are important matters to be sure, but they must be understood in connection with the patterns of belief evoked by legal symbols. In its symbolic form, the law shaped the context in which American politics is conducted. Alerting us to the law's symbolic life and power, Steingold imparts from the conventional view that law and politics are distinct realms. Although neither the first nor the last to argue for a political analysis of law and rights, nor alone in focusing on the symbolic and ideological character of the law, Steingold offers a unique and compelling depiction of the law's hold on the popular imagination in America. Like all fundamental social institutions, law casts a shadow of popular belief that may ultimately be more significant, albeit more difficult to understand than the authorities, rules, and penalties that we ordinarily associate with the law. What we believe reflects our values. It also colors our perceptions. What we believe about the law is directly related to the legitimacy of our political institutions. Steingold dubs this popular belief that the myth about the law, the myth of rights. The myth of rights is an ideology that rests a faith on the political effigy and ethical sufficiency of the law as a principle of government. In contrast with the distrusted political branches of government, the courts and the Declaration of Rights issued by the judiciary are perceived as both legitimate and effective for the task in securing a just society. Those who subscribe to the myth of rights, as Steingold explains, believe that the political order in America actually functions in a manner consistent with the patterns and rights and obligations specified in the Constitution. The ethical connotations of this rule of law system are based on the willingness to identify constitutional values with social justice. It encourages us to break down problems into the responsibilities and entitlements established under law, with the same way that lawyers and judges deal with disputes among individuals. Once the problem is analyzed, the myth, moreover, suggests that it is well on its way to resolution, since these obligations and rights are not only legally enforceable, but ethically persuasive because they are rooted in constitutional values. Like all ideologies, the myth of rights defines a particular program of social action as legitimate and worthy of support. Captivated by the myth of rights, people commonly believe the judicial declarations of rights will directly translate into social reform. With this faith in the legal paradigm, activists deploy litigation and turn to the courts at the expectation of fair redress for perceived wrongs. The assumption is that litigation can evoke a declaration of rights from the courts, that it can further be used to assure the realization of these rights, and finally, the realization is tantamount to meaningful change. The myth of rights, in other words, is premised on a direct linking of litigation rights and remedies with social change. This optimism and faith generated by the myth of rights has a strong allure, for it bolsters our confidence that the rule of law prevails. But the allure, Steingold warns, is problematic because more often than not, law merely reinforces the status quo and maintains prevailing arrangements of power. A sober assessment of the status of rights in American politics raises serious doubts about the capabilities and legal constitutional processes for neutralizing power relations. The authoritative declaration of a right is perhaps best viewed as the beginning of a political process in which power relations loom large and immediate. Furthermore, the seductive power of the myth of rights engenders complacency by creating false hope in the power and efficacy of the legal system. Once a right has retrieved legal authorization, those who subscribe to the myth, assume that the right has been actualized. Under the veil and myth of rights, we are inclined to believe that the gaps in rights articulated in the rights effectuated do not exist, or are anomalies that can be easily overcome. And this is it. the myth of the bypass. In the context of the parental involvement laws, the myth of right fosters an idealized view of the bypass process with assuredness and without skepticism. Those who are lured by the myth of rights presume that the courts will be prepared to handle the bypass requests, that minors will have access to those courts, and that by and large the judges will treat the requests neutrally. The reality of the bypass process exposed in the preceding pages seeks to dismantle the idealization that surrounds and upholds parental involvement laws. But those who succumb to the myth of rights may hold fast to the ideology, saying that at most what has been shown is that the bypass needs fixing, not that involvement statutes should be discarded altogether. The protections afforded by the statutory law and the Constitution, they may assert, provided the necessary shield against right infringements, even when the shield becomes permeable, obvious rights infringements will not long endure. This line of argument goes as follows. Legal systems inevitably suffer instances of failed implementation resulting from both innocent misapplication and deliberate opposition to the law. While troubling, we expect to maintain a legal system, we must tolerate some missteps. Were we to reverse this policy in every instance of error, no policy would survive. The answer to implementation problems associated with the bypass process on this view is not a reversal of the policy, but instead the creation and implementation of additional measures to check and minimize these problems. Furthermore, the legal system affords the opportunity by way of appellate review to reverse errors that emerge when laws are misapplied. If this bypass route is defective, minors can sue to redress the defects, just as others have resorted to litigation to remedy rights violations. And the fact that we have witnessed much in the way of legal challenges to the bypass option might be taking as evidence that the system functions reasonably well. Plausible as this might sound, it is nothing more than an iteration of the myth of rights. As Karen Bodner explains in our analysis of the limits of anti-discrimination regulation, the argument rests on the assumption that the legal system affords the necessary tools to generate compliance with the law, and the victims of noncompliance can readily and with little sacrifice access these tools. This assumption is false in both the case of the anti-discrimination law and, as Boomer has shown, in the case of pregnant teens. The obstacles awaiting a pregnant minor who attempts to repair defects in the bypass process and then the bypass can make the prospect of a legal challenge decidedly unlikely. Take the minor who encounters ignorance or misconduct at the stage of attempting to gain access to a hearing. It's almost unimaginable that a minor turned away from our county court would have the capacity to not merely seek a bypass elsewhere, but to sue the state itself. With the clock ticking on her pregnancy and thus on her ability to secure an abortion, a minor is certain to focus on the immediacy of her situation. The prospect of taking on an arduous legal battle is outside of her realm, and in fact, such a minor would have no idea that her rights are even being violated. What's more, a minor seeking to bypass typically does so to keep her parents from learning of her pregnancy. In this context, it's rare the minor is going to take on the increased risk of discovery to wage a legal campaign against the state. Were a minor to have the wherewithal to sue the state, it's far from clear that such behavior would even be in her interest. Consider the minor who succeeds at getting her foot through the courthouse door, is assigned a lawyer, files a petition, and winds up before a trial judge who requires save-a-life counseling or the presence of fetal representation, in this case despite having counsel, and hence when the wherewithal are aside, the option of mounting a challenge in advance of the hearing must seem unfeasible, and thus even ridiculous. As it is, a minor petitioning to waive parental involvement does so with considerable apprehension. Such a minor confronts not only the stress of an unwanted pregnancy and the prospect of terminating pregnancy, but also a hearing before an authoritative stranger whose decision may dramatically alter her life. Generally, they're so frightened to be there, one attorney said of minors who appear before the judges in waiver hearings. To imagine that such a minor would escalate this anxiety with a legal challenge when she can instead yield to the court's procedures and thereby attain a hearing is to ignore the vulnerable position in which the minor finds herself. Again, a minor who pursues such a challenge runs an increased risk that her parents will discover her situation. Add to this the time and pressure of an advancing pregnancy and an additional stress associated with the protracted legal proceedings and a less than certain appellate outcome, and we should hardly be surprised that when presented with the option of initiating a lawsuit, a minor would decline. As one attorney explained, the judges want the girls to go to save a life. I tell my girls and I tell them you can go and listen to what they have to say, or we can appeal that. Most of them just go and get over with it. I haven't had a girl said, no, I won't go, and instead challenge it. Even when the attorneys believe that judicial bypass during hearings violates a minor's rights, they are hard-pressed to encourage a young woman to file a legal challenge. According to some attorneys who represent minors, serving the client in this type of case requires preparing a waiver that requires rather than objecting to what might amount to impermissible hurdles placed in the minor's path. As one attorney explained, whether I believe that those little girls should say that she's prayed about it and she thinks it a sin, whatever hoops she has to go through, she can jump through and get her waiver as long as that happens. I'm happy. When asked whether objections to these hoops getting raised at hearings, the attorney said, "Do I object? No, because the waiver would be denied, and I would have to take it up on appeal. I don't know what the Court of Civil Appeals would do," emphasizing the reality of pursuing a bypass in the Bible Belt. Before conservative judges, this attorney defended her approach. This is the system I work under. The system is what those judges believe. As long as they follow the law, the ethereal constitutional right of being unduly burdened doesn't matter. And if it were my choice, she would do a two-step and get her waiver. Yes, these judges place more of a boulder in the pathway of abortion, but it's the system. It is the system, and challenging on the basis of that is not going to help these girls. And if I do that, if I challenge all of these questions of religion and whatever, I'm not going to get appointed to these cases. And I tell them that you have the choice to terminate your pregnancy. This is not wrong. This is a constitutional right. My God, you have the right to do with your body what you want to do. But let me tell you how we're going to do this hearing. Another attorney also highlighted this reality by explaining how implementation of the bypass process goes unchallenged. Who's going to stop it? Our judges do what they want to do and when they want to do it. If you care about the next client and paying your bills, you have to get along with the judges. And what are you going to do? Ask them to recuse themselves? They won't recuse themselves. And all you've done is ask them to recuse themselves. Then you have to deal with them. That can hurt your next client. While prior and contemptuous challenge to judicial procedures and bypass hearings is implausible, it may not seem so far-fetched to think that such a challenge could emerge once a bypass petition has been denied. With an expedited avenue of appeal available and legal counsel already appointed, minors have in fact appealed judicial denials of their petitions, but these appeals are the main order of business from the minor's perspective in getting the denial reversed, not in challenging the process itself. These appeals typically concern whether a judge has properly applied the maturity and best interest standards, and whether with minors, for example, the judge failed to arrive at finding the best interest prong, or failed to specify the grounds for denying the petition. A minor may understandably be reluctant to complicate the appeal with a process-oriented challenge that questions the constitutionality of such things as a stable life mandate of a fetal representation. Such reluctance is especially understandable when the appellate courts have shown a lack of enthusiasm for taking up challenges, and when attorneys, like the one cited above, express doubts about the prospects of winning on such grounds. Minors and their attorneys cannot be faulted for choosing pragmatism over principle. It may seem fair to say that the nature of the situation compels this sort of pragmatism. The situation here is not analogous to the state regulator of businesses of adult persons who are in a better position to challenge burdensome state regulations should they believe it to be necessary. Pregnant minors are in no such position. Adopting this pragmatic approach helps perpetuate the myth of rights, and therefore lies the rub about the myth of rights. The myth is sustained by the tendency of the mind towards idealization, and if such cases were adjudicated in Plato's courtroom. But in the world, it is sometimes necessary and often rational for those without resources or power to tough it out. There are worse things in the world than having one's rights violated. So unless we see through the facade of the bypass that ignorance and bureaucratic obstacles will continue to encounter judges who conduct these hearings in ways that fail to match up with our expectations, and minors will continue to tough it out in silence and out of sight, reinforcing the mistaken impression that the bypass option functions reasonably well. The myth of separation. The actions of the recently emboldened religious right have made it easier to appreciate that the supposed neutral and objective arbiters of our legal justice system use the courts to advance their ideologies. The behaviors of Judge Anderson and Campbell in Montgomery, Alabama, as well as the numerous reports of judges who refuse to handle bypass petitions without taking steps to assure a replacement judge, are instructive. and whether more evidence outside the bypass cases or even the abortion issue demonstrates that the courts have embraced rather than eschewed religious ideology. Take the case of Roy Moore, a former Chief Justice of the Alabama Supreme Court. Before his position to that election to that court, he served as a circuit court judge and earned renown for displaying hand-carved plaque of the Ten Commandments behind his bench and for inviting clergy to lead prayer at jury organizing sessions. During his run for the High Court, his committee christened him the Ten Commandments judge, using the monkey in his campaign publication and other advertisements. And although his election to the state's High Court, Justice Moore made good on a campaign promise to restore the moral foundation of law by designing and commissioning the production of a 2.5-ton granite monument of the Ten Commandments for display at the courthouse. On the evening of July 31st, 2001, on the orders of the Chief Justice, the monument was placed in the rotunda of the Alabama State Judicial Building. Although Moore did not notify his colleagues of the court on the installation, he did inform Coral Ridge Ministry, as a Christian evangelical organization, and gave the group exclusive privilege of filming the event. In the public ceremony of the day after the commandment's installation, Chief Justice Moore said the monument will serve to remind the appellate courts and judges of the circuit and district courts of the states that the members of the bar who appear before them, as well as the people who visit the Alabama Judicial Building, know the truth stated in the preamble of the Alabama Constitution that in order to establish justice, we must invoke the favor and guidance of the Almighty God. Further testimony of his purpose came later during the lawsuit challenging and subsequently returning the installation. More specifically, Moore conceded that his goal was to acknowledge God's law and God's sovereignty and God's overcoming power and over the affairs of men, and that God to whom he was referred to, the Judeo-Christian God. It's perhaps worth noting that Moore's tenure as Chief Justice of the Alabama Supreme Court replaced the standard for reviewing bypass denials with one far more deferential to trial judges. Similar religious testimonies, less publicized and less grand in scope, have emerged from the bench. In December 2004, a circuit judge in Covington County, Alabama, came to the court sporting the latest in judicial fashion, a robe embroidered with the Ten Commandments, explaining his new garb. Judge Ashley said the Ten Commandments represent the truth and that you can't divorce law from the truth, and that the Ten Commandments can help a judge know the difference between right and wrong. He further explained his desire to acknowledge the scriptural foundation of modern law without biblical truth. They said there is no law. Enthusiasm for displaying the Ten Commandments is not peculiar to Alabama judges. In July 2000, Judge James Weezy of the General Division of the Court of Common Pleas in Reed County placed the framed poster of the Ten Commandments in his courtroom opposite a similarly framed poster of the Bill of Rights. During the legal proceedings, it ultimately led to the federal court order that the display be removed. The witness testified that he intended to use the documents for educational purposes, but specifically to discuss the origins of law, legal philosophy, and the rule of law. But as the Sixth Court of Appeals explains, he also testified that he chose the Ten Commandments because they were emblematic of moral absolutism, and he chose them to express the belief that law comes from either from God or man, and to express the belief that the law of God is the authority, and that he explained that in the course of the educational efforts, he would point to the Ten Commandments as an example of God as the ultimate authority in law. Other judges have revealed in religious inspiration without putting the Ten Commandments on view. A court judge in Kentucky included a spiritual option when sentencing those convicted of a misdemeanor drug or alcohol crimes. Judge Michael Caperton, a devout Christian, has offered 50 substance abuse offenders the option of attending worship services in lieu of rehabilitation or serving jail time in jail. For example, Scott Lee's convicted misdemeanor drug charge faced a choice of 10 days in jail or a drug rehab program or 10 worship services. Leaning towards the spiritual options, he has said services for 10 days rather than 10 in jail 10 days. Who wouldn't, Judge Caperton asserts that the alternative status poses no establishment cause concern because it's not mandatory that I say that my services instead of church, but he also explains the Associated Press report that the church guidance could help some of those convicted find spiritual guidance. In each of the above cases, as in the case of Anderson versus Capel, judges have decided whether literally or figuratively to wear their religious views on their sleeves, whether or not their actions are consistent with the Establishment Clause. These judges remind us that they are susceptible, like ordinary human beings, to the influence of religious ideology. These reminders should help us admit that the separation between law and politics is folklore. a story repeated to try to convince ourselves is fact, while the world around us tells us that it is a fiction. These reminders should help us admit that the particular separation between religions and the courts is a tall tale, a promise not fully realizable. It might be countered that the preceding examples are analogous and that by and large judges do their best to contemplate these religious and political ideologies while serving in their capacity as jurists, but there is at least as much reason to suspect that these examples just touch the tip of the iceberg and are emblematic of strong undercurrents that shape judicial decision-making. To be sure, judges socialize into the view that they must remain neutral and thus they should interpret law rather than make law. In short, they should not legislate from the bench. Jurists routinely profess this perspective on judicial decision-making, as did Justice John Roberts during his confirmation hearings before the Senate Judiciary Committee. Judges and justices are servants of the law, not the other way around. Judges are empires. Empires don't make the rules, they apply them. The role of an empire and the judge is critical. They make sure everybody plays by the rules, but it is a limited role. Nobody ever went to a ball game to see the umpire. Judges are not politicians who can promise to do certain things in exchange for votes. I have no agenda, but I do have a commitment. If I'm confirmed, I will confront every case with an open mind. I will be fully analyze the legal arguments that are presented. I will be open to the consideration of the views of my colleagues on the bench, and I will decide every case based on the record according to the rule of law without fear or favor, to the best of my ability, and I will remember that it is my job to call balls and strikes and not to pitch or bat. This rhetoric of objectivity, however, is up against competing forms of socialization. These forms, including political, moral, economic, and religious joint objectivity on the psychological battlefield, and there is no telling in advance how the competition will play out. As a final example, we consider a county judge in Texas who received warning from the state's Commission on Judicial Conduct for appearing in a theological seminary advertisement donning his official judicial robe. Responding to this warning, Tarrant County Judge R. Brent Kess appealed to his secretary in Judy. While the Texas Code of the Judicial Conduct stipulates that a judge shall not lend prestige to the judicial office to advance the private interest of the judge or others, Judge Kells defended his decision to appear in the advertisement, saying, "I know that my religious faith is the only answer to the seminary request. It is my sincere religious belief that for me to have said no to such a request would be denying Christ, and thus this I cannot do." The seminary spokesperson applauded Judge Kells, and in doing so offered an apt characterization of the secretary's influence on the judge's actions. In our today, many people want Christians to compartmentalize their faith. They want a politician to be a politician, not a Christian politician. They want a teacher to be a teacher, not a Christian teacher. In this case, they want a judge to only be a judge and not a Christian judge. Judge Kells understands that faith in Christ is expressed in every part of his life. Faith in Christ does not check packages as he leaves his office at the courtroom door. I applaud his faith and willingness to endure the sanction for Christ. Whatever a judge's faith resides in, and whether or not a judge tries to check on his or check her ideological baggage, there will always be at least some carry-on items that make their way into the courtroom. Chief Justice John Roberts' romantic vision of the judge as a neutral umpire pretends that it could be otherwise. But the analogy, as Peter Edelman of Georgetown Law pointed out during Chief Justice's confirmation hearings, is remarkably disingenuous. Roberts said the other day that judging is like being an umpire, just calling the balls and strikes, and I'm not one for adding to the piles of sports analogies here, but if the umpire stands 2 steps to the right behind the catcher, strikes are going to look like balls, and many balls are going to look like strikes. Constitutional interpretation is not like calling balls and strikes. It has not been my intention to suggest that judges who bring ideology to bear on their official activities are doing something wrong, but as if the point here were to follow the observation of this commingling with that motion, don't do that. Rather, the point is to once and for all admit that there is really nothing else these judges can do. We ought to take into account for the fact that when we form our expectations about how proposed laws will operate, and indeed take into account these newly enlightened expectations when to decide whether a law is a good idea in the first place. Conclusion. On November 30th, 2005, the Supreme Court heard oral arguments in Annett versus Planned Parenthood of Northern New England, a case addressing the constitutionality of New Hampshire's parental notification requirement. Under dispute was the statute's lack of an explicit exception allowing a physician to waive notice when a minor's health was at risk. The state argued that the judicial bypass process provided sufficient protection even in the context of a medical emergency, responding to Planned Parenthood's contention that forcing a minor to obtain a judicial waiver in an emergency could lead to a dangerous delay in the receipt of medical care. Justice Scalia said, "Counsel, surely not the delay for a quick phone call. Let's assume that New Hampshire sets up a special office open 24 hours and this abortion judge, and he can be reached at any time, anywhere. It takes 30 seconds to place a phone call." Scalia is perhaps a bit too optimistic. The judicial bypass compromise is designed to balance competing rights and interests. It's sustained by the premise that the courts function largely apolitically and without bureaucratic pitfalls. The preceding pages call this premise into question, basing a policy that regulates the right to abortion on confidence that the law stands outside of politics and free of bureaucratic red tape is a mistake fraught with consequences for whom the right ostensibly protects. This is far from the first time evidence has shown sizable gaps in the implementation of the law. Failure to comply with the Supreme Court's ruling in Brown versus the Board of Education is by now long established in providing what may be the most salient example of the disjuncture between idealized rights and actual practice. Still, our illusions persist, and few people care to entertain whether the world actually accords with our imagination. The rhetoric of judicial competence and objectivity abounds, perpetuated by the dogma that the courts are situated in a realm replete and safe from the political tug-of-war. Is this unseemly discussion? Asked Sutherland and Julie Kantz in the highlighting acts of judicial discretion. After all, we believe that judges will rise above differences between themselves and the litigants before them in order to make a fair and equitable decisions. This is indeed an unseemly discussion, at least to the rose-tinted lenses of the myth of rights. But sometimes it takes the unseemly, the admission of ignorance, inefficiency, and incompetence and defiance to dislodge mythologies and to disabuse ourselves of the notions that we can be what we are not. And that is the end. It's all, of the citations of the book at the end of all of this. So you've just, finished. Our system, our judges in our society are not objective. It is a lie that they are. It is an illusion. The people who believe it are delusional at absolute best, and this is necessarily true. Ideology, politics, all of it infects the courtroom. It has bled its way into it, as we have now laid down the case and proven. There is no outside of politics. It is in our courtrooms. Our judges are fiercely partisan, political, and ideological, and they are far from objective. Objective is the last word they will ever be. They are the further. In fact, they could not be further from objectivity. That, literally, they are as far from it as it's possible to be. The distance between them and actual objectivity is about the distance between here and the light of stars that are now, because of the rate of expansion of the universe, beyond the ability for us to actually ever receive the light of. That's how far removed they are from the myth, the ideology that these guys are objective. As far as it is fucking possible to be. Anybody who believes otherwise is delusional.